Welcome to the 8th video of a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. As we noted in the other videos, I'm intentionally giving away all of the substantive content of that book. If you watch all 9 videos and internalize the concepts explained in those videos, you will have expert knowledge of interrogation law without spending anything but your time. I think you will find, however, that the book, and particularly the many case examples found in the book, are a valuable supplement to your viewing of the videos. It is bargain priced and available for purchase on Amazon. But if you choose not to buy the book, the free YouTube videos stand on their own and provide real value to viewers. So, on to today's lesson. This is video 8, which covers exceptions to the exclusionary rule, impeachment, and fruit of the poisonous tree. When courts exclude evidence on Miranda or similar technical grounds, defendants may feel emboldened to lie on the witness stand. In most cases, courts won't protect defendants who do this. A defendant's statements that are inadmissible in the government's case in chief may be used in cross-examination or rebuttal if the defendant tells a different story on the witness stand. This sort of impeachment is typically admitted as a prior inconsistent statement that attacks the testifying defendant's credibility. On request, jurors are instructed to limit the use accordingly and not to use it as substantive evidence. For example, if a defendant confesses to a murder and the murder confession is suppressed because a detective violated the Miranda rule to obtain the confession, and the defendant takes the witness stand at trial to deny it committing the murder, the prosecution will be permitted to cross-examine the defendant about the confession. That's called impeachment. And if the defendant denies confessing, call the detective to testify about the confession in rebuttal. At the request of the defendant, the jury would then be instructed that they may consider the confession in determining whether the defendant was lying when he or she testified that he or she did not murder the victim, but the government cannot use the confession as substantive evidence that the defendant committed the murder. This is a legal distinction that will be lost on many, if not most, jurors. And defense attorneys know this. So in most cases, the defense will avoid the issue by resting its case without calling the defendant as a witness. As explained in the self-incrimination video, the defense may also be able to persuade the court to exclude evidence of a defendant's silence on Fifth Amendment grounds in the government's case in chief. But if they put the defendant on the witness stand, the prosecution can cross-examine about the silence because defendants effectively waive the Fifth Amendment when they testify. Examples of otherwise inadmissible statements available for cross-examination or rebuttal include statements made after any Miranda violation, both failure to warn and invocation violations, statements taken in violation of the Sixth Amendment right to counsel, statements to pretrial services officers where statutes otherwise make the statements inadmissible, statements made by the defendant testifying in support of a motion to suppress, or statements obtained by illegal wiretaps. There are 3 types of statements that cannot be used to impeach testifying defendants. Statements that the defendant made involuntarily. Involuntary statements are never admissible at any stage of the trial. Silence of a defendant after being advised of the right to remain silent. This is the Doyle rule we discussed in the self-incrimination video. Any use of a defendant's silence after being advised of the right to remain silent violates due process. And finally, statements that are inadmissible because they were compelled pursuant to a grant of immunity. As explained in the self-incrimination video, competent prosecutors will avoid this problem by obtaining a waiver as part of the proffer or plea bargain process. Otherwise lawful and voluntary confessions are sometimes obtained after the police have made an unlawful search or detention in violation of the Fourth Amendment. In those cases, courts apply the fruit of the poisonous tree rule. Courts must ask whether the derived evidence had been come at by exploitation of the illegality or instead by means sufficiently distinguishable to be purged of the primary taint. That's referred to as attenuation. This is determined by applying four Brown factors: the voluntariness of the statement, the time elapsed, sometimes called temporal proximity, between the illegality and the acquisition of the evidence, the presence of intervening circumstances, and the purpose and flagrancy of the official misconduct. Intervening circumstances would include the presence or absence of Miranda warnings. Alternatively, the exclusionary rule does not apply if the government has an independent, untainted source, or the evidence would have been inevitably discovered. Where an otherwise voluntary confession follows an involuntary confession, the first confession is obviously inadmissible, but the second confession may be admitted. The test is whether the second statement was so closely related to the first that the facts of the first control the second. A voluntary statement tainted by a Miranda violation does not normally spoil a later statement obtained after a proper Miranda waiver. Some officers over the years have viewed this as a loophole and have intentionally omitted warnings to obtain the initial confession with the intent to get the suspect to repeat the confession after a Miranda waiver. The Supreme Court addressed this intentional two-step procedure in Missouri versus Seibert in 2004, holding that if the first statement was obtained in a calculated way to undermine the later warnings, a later confession obtained after a Miranda waiver is only admitted if curative measures are taken. Curative measures are measures designed to ensure that a reasonable person in the suspect's situation would understand the import and effect of the Miranda warning and waiver. This could include a substantial break in time and circumstances between the two statements, or an additional warning that explains the likely inadmissibility of the pre-warning statement. Physical evidence discovered as the fruit of an involuntary statement is inadmissible. The law on this is well developed in cases where the suspect has, purposely or accidentally, been granted derivative use immunity. You can review all of this in video 3 of this series. There are two types of Miranda violations: failure to warn violations, that is, failure to read the Miranda rights, and invocation violations, failure to honor invocations of the right to silence or the right to counsel. The law is settled that failure to warn violations have no fruit of the poisonous tree effect on the subsequent seizure of physical evidence. Some courts take a different view if it's an invocation case. There is no definitive case law on whether or not, or to what extent, a statement or physical evidence may be suppressed as the fruit of a violation of the Sixth Amendment right to counsel. So, you made it to the end. Thanks for that. If you have comments about the presentation or questions about some of the points I've tried to make in the video, I can be reached by email at contact@trialdex.com. This was the 8th video in a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. The next and final video covers suspects who raise mental defenses. I hope to see you there.